Hi guys, welcome back to another video at Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new video on your episode 9 for a legal Darpan, that is a peek into your legal current affairs. So every week we are holding this session for giving you the legal updates that have happened in the past week or month. So do make sure that you're hitting on the like button, and also don't forget to hit on the subscribe button so that you are able to get all the updates regarding the channel regularly. Now, if you are new to the channel for our YouTube, do make sure that you are also subscribing to our Telegram channel for all these regular updates so that we can keep guiding you regarding these exams regularly. So, the first news of the day, that the retired IAS officer Mr. Arun Goyal has been appointed as the new election commissioner of India. So if you know that the election commissioner of India is always given a oath by the president of the country. So President Draupadi Murmu has appointed him as the election commissioner, and with effect from the date he assumes the office. Now he is the chief election commissioner Sushil Chandra, who has been retired right in May this year, handing the charge to Rajiv Kumar. Now from Mr. Rajiv Kumar, Mr. Arun Goyal will take this position. The poll panel has been two-membered since and had handled several crucial issues regarding the disqualification of Jharkhand Chief Minister Mr. Hemant Soren. So this is a very important news. As you know that we were just discussing in our last session that the Supreme Court has tried to question the government regarding the short tenure of the people who are there in the election commission. So that is something that needs to be understood, and they have also questioned it. Now you can see there is a new person who's been appointed as the election commissioner of India. Now coming to the next point of the day, that is that law commission constituted after 4 years, right? So Justice Ritu Raj Awasthi is appointed as a chairperson for this law commission. Now coming to the first part, is this is the 22nd law commission, and it's constituted for 3 years, and the 22nd Law Commission was notified on February 24th of 2020. As you know, after that there were a lot of things that have happened in the entire world. Now the law panel has been lying vacant since the retirement of the former Supreme Court Justice B.S. Chauhan in 2018. So it's been a long time that we haven't had a law commission in our country, and an important issue to take on for this was that the government has to set the issue related to the uniform civil code might be taken up in the 22nd law commission. So we have heard about the civil code, right, where every human will have the same rules for heredity of their properties, marriage, everything will come into a uniform way. That is called a uniform civil code. Now the other members from this institution are former Kerala High Court Judge Justice K.T. Shankaran, Professor Anand Paliwal, Professors D.P. Verma, Professor Raka Arya. This is a professor from one of my universities called NLIU Bhopal, and I have been taught by Ms. Raka Arya, and also M. Karunanidhi, who have been appointed as a member of the commission also. So these are some of the members who are there in the law commission that have been constituted after 4 years exactly. Now coming to the next part, what is this Law Commission of India? So Law Commission of India, it is neither a constitutional body nor it is a statutory body, right? But it is an executive body that is established by an order of the government of India. It is the major function of this reform is to go ahead and bring legal reforms in the country. Now, commission was established for a fixed tenure and works as an advisory body to Ministry of Law and Justice. It is the membership primarily comprises legal experts, because obviously it is a law commission and it is trying to reform the legal justice system of the country. So definitely that is something that needs to be there. Now, this is a case that have come up in the Delhi High Court, that is 18 years after the murder conviction. Delhi High Court sets aside a life sentence as ossification test reveals convict was a minor on the date of the incident. So you can see that the life of the person who was in the jail was for 18 years that he has stayed in jail. So he's been growing up in jail basically. Now in the case that was dated back to 1999, the Delhi government has set aside the life sentence of a convict after he took the plea of the juvenility during the pendency of his appeal. The ossification test revealed that his age was between 10 to 20 years old on the day of the incident. That means that there was a chance that he was a minor on the day when it happened. Now, considering the fact that the upper age limit cannot be taken to determination of the appellant, and as per the lower limit, the appellant was a minor at the time of alleged incident, he is entitled to the benefit of the juvenility. So he was given the juvenility excuse, right? He was given out this particular benefit that yes, he was a juvenile at the time of the murder was happened at that moment, so he was conducting as a juvenile in that case. So definitely this is an exception to the murder law, that if you are a juvenile or of an unsound mind, you will not be considered guilty. So that is why he's been given his judgment is being set aside for the life imprisonment. Now coming to the next part is that the appellant was convicted for punishments under 302, obviously murder, 452 of the IPC, maintaining the conviction of the appellant for the said offences, which is not being challenged on the merit before this court. The order on the sentence is set aside. Obviously, the division bench of Justice Mukta Gupta and Justice Anish Dayal in the judgment dated November 23rd further observation that in any case the conviction will have no disqualification at any stage against the appellant terms. That means that there will be no disqualification. Now he will be released because he will be under the Juvenile Justice Act. Now, women can also be held guilty for outraging a woman's modesty, right? So that's what the Mumbai High Court has said under the section 354 of the Indian Penal Code here. Now, the Metropolitan Magistrate Court in Mumbai said that a convict of under section 354 of the IPC, as it is being gender neutral, the offender and thus convicted and sentenced a mother of 3 to 1 year rigorous imprisonment for outraging another woman's modesty. So you can see that these cases are now being tackled very, very tactfully by the court because the IPC doesn't specify any gender. ठीक है कि कोई जेंडर नहीं बताया कि मेल ही कर सकता है outrage modesty of a woman, but a woman can also do that. That is definitely possible. So that is why the court held this mother of 3 to 1 year rigorous imprisonment. And also the section 354 operates equality upon all persons, whether males or females, and it cannot be maintained that women are exempted from any punishment under this section. So that's what the Metropolitan Magistrate Manoj Vasaran Chavan has observed. So that is why she's been punished under this case. Now, arbitration clause in an agreement cannot be invoked for another agreement, right? So it should be on the basis of that operating agreement only. That means they are operating independently. That's what the Bombay High Court has said, that a rule that mere reference to an agreement containing an arbitration clause, right, in a subsequent agreement will not bring about a consequences envisaged under section 7(5) of the Arbitration and Conciliation Act of 1996, to the effect that arbitration agreement will be incorporated into the subsequent agreement. Now, the court also added that the reference contemplated under section 7(5) of the Arbitration and Conciliation Act should be such so as to make the arbitration clause a part of the contract. अगर किसी और contract में लिख दिया गया है कि हाँ इस कॉन्ट्रैक्ट में आर्बिट्रेशन की बात हुई थी, तो आप उसको इन्वोक नहीं कर सकते. You need an independent arbitration clause in your agreement if you want to invoke that clause according to the Arbitration and Conciliation Act. Now, Punjab and Haryana High Court has allowed a minor rape victim for a plea of termination of pregnancy at 26 weeks. It is set on 24 weeks. But there was a rape victim who was allegedly 17 years old and the pregnancy was on 26 weeks. The Punjab and Haryana court observed that the child, if born, would be a reminder of trauma and agony for the minor. And Justice Vinod S. Bharadwaj said that an unwanted child, the member, is also likely to either live a tormenting life filled up with taunts to his origin or only be given away. In either of the said situation, the mother as well as the child suffer social stigma and incarceration for their rest of their lives, which is absolutely right. So that is why they told that this pregnancy can be terminated even if it is at 26 weeks. Okay. The court added that it is under the best interest of the child and the mother's family, because the minor's family has always and also put up their unwillingness to take care of it. The unborn will grapple to come on to terms with life and subjected to maltreatment for no fault, it said. Okay, such decisions are tough. However, life is not just about being able to breathe, it is about able to live with dignity. Okay, where denial of dignity and society as well as family acceptance or approval is a writing on the wall, it compounds agony of the child and lead to greater injustice. That means giving birth to this child will lead a injustice life to him. Now, whether to shape the trauma of the victim or to prolong it to be by delivery of the child who is only victimized, thus reduces the choice, seems more prudent to allow the termination of such pregnancy. So you can see that the court also understands the philosophical and psychological phenomena of the person who is in question. They are not just taking care of the only part कि हाँ termination कर दो because she is a minor and she has been a rape victim, but they are also thinking about the child and also taking it one level deeper than what you would have thought. So that is why it is the rule, it is the value that the judge carry, and also it makes us understand how well read and how sensitized they are right now in such cases. Okay, now sexual harassment of a child is a cognizable and a non-bailable offence. That's what the Delhi High Court has said. That the Delhi High Court ruled that sexual harassment of a child, which is punishable under Section 12 of the POSCO Act, is a cognizable and a non-bailable offence. And also, the Division Bench of Chief Justice Satish Chandra Sharma and Justice Subramania Prasad said that the offence would fall within the scope of second category of Part 2 of Schedule 1 of the Code of Criminal Procedure, that is CRPC. Now, the said category states that if the offence is punishable with imprisonment of 3 years and upwards, but not more than 7 years, then it will become cognizable and non-bailable offence and will be triable by a judicial magistrate of first class. Right? So that's what is being said regarding the case of sexual harassment. This is the Section 12 also talks about that whatever or whoever commits such harassment upon the child shall be punished with imprisonment which may extend to 3 years. A pursual of Part 2 of the Schedule 1 of the CRPC also says the same. Now coming to the next part is that there must be a causal connection between the breach of contract and the loss sustained by party claiming damages. So that's what the Calcutta High Court has said, that for claiming damages, there needs to be a connection between such breach of contract and loss sustained by the party who suffered the breach. Now coming to the next part is that the general aim of law of damages is to protect the innocent parties, right, who are defeated the financial expectations and compensate him for the loss of bargain, subject to the rules of causation and remoteness. There must be a causal connection between the breach of contract and the loss sustained by the party who suffers the breach. The important issue is whether a particular loss was within the reasonable compensation of the parties or not. Right? So this is it for today, guys. I hope you were able to get some recent news about these weeks, and also in the month of November we have collected all the news for you so that you are able to get it properly under one roof only. So do make sure that you are hitting on the like button, and also don't forget to hit on the subscribe button for the regular updates. And if you are not a part of our Telegram channel, do make sure that you are subscribing to our Telegram channel under the name of CLAT@Pratham for all these regular updates. And if you are a student who's looking for help or wants to talk to a mentor at Pratham, do make sure that you're giving us a call on 5 times 9 75392 for any test series material or international education. Do make sure that you subscribe to this channel and also do take care of yourself. And thank you and have a nice day ahead.